SJC-11512, Commonwealth v. Daniel Lewis.
Great. Now, Mr. Black.
Sorry, I'm kind of in an awkward position here, trying to get notes all over the place since I'm not at my desk. Good morning, Chief Justice. Good morning, Justices. My name is Alan Black. I represent Daniel Lewis in this matter, both on the motion for new trial, of course, and the appeal.
Mr. Black, is there a difference with the analysis with the CSLI and the text messages?
No.
They rely on the Rule 17 affidavit?
The cases that I cited, Carpenter and Augustine, treat them the same, and Carpenter treats them the same. You need probable cause and you need a warrant. So they're both, I believe they're both the same under those decisions.
Standard of review the same?
Excuse me?
Is the standard of review the same?
I think so. That would be my opinion.
All right, because there's issues as to precisely what was preserved.
Well, there is. I mean, I would absolutely agree with that statement of what's preserved and what wasn't preserved. He did object to the admissibility of both, I believe, when they were coming in. He did not file any motions, but of course, at the time, probable cause was not the standard.
Yeah, but the objection on the text messages is that he didn't have enough time with them, not probable cause, and nothing to do with, not that Fulgham existed, but nothing to do with Fulgham or Augustine. It was on how little time he had the text messages.
Well, it's true. We had the text messages for 2 days, and that shouldn't have happened because the Commonwealth withdrew their motion to get them.
No, I appreciate that point. That's a good point. The Commonwealth even recognizes that's a very good point. But nonetheless, the question was whether or not the text message is preserved.
So if you go back to this issue when it comes up in trial, and I just did about 10 minutes ago, he uses the word probable cause, and the court says you don't need probable cause. That's my understanding of the discussion, but please, obviously I know you'll look at it, but look at it because that's what I think was said. But he did use the word probable cause, and the judge said, they didn't need it under 2703. That's my memory of it.
And your view is there anything different between looking at an affidavit under section 2703 or a Lampron affidavit as far as whether or not there's probable cause? Because this is obviously tried well before Augustine.
Way before Augustine and before Carpenter as well. But of course, I argued that they were retroactive. That's an interesting question because there's definitely a difference between the probable cause and Lampron and 2703. They're more alike than the analysis for probable cause. And then the judge recognized that the analysis for probable cause, he said, I don't have to do an analysis under probable cause because it's not required. And it certainly wasn't then. So he didn't do the analysis, the judge didn't do the analysis under probable cause because it wasn't required. The trial attorney objected anyway. And, the scope of the objection, I think he said the word probable cause, but I don't know for sure. But in any case, I would argue it didn't meet the probable cause standard because it didn't have to at the time. But now Carpenter and Augustine changed the law, the constitutional law, in my opinion, and therefore under the Teague-Bray standard, I think it's absolutely retroactive.
Well, you know,
Anything
the
else?
Commonwealth, go ahead,
Sure.
excuse me, Mr. Black.
I'm sorry.
No, go ahead.
No, I just wanted to know if you had any other follow-up questions about that point.
Well, you know, the Commonwealth is going to argue that the probable cause is strong here with the text messages with Mr. Pierce to the victim, the would-be first victim, the conversations, I think it's Mr. Abrams maybe, with the defendant concerning the gun and the use of the telephone, the cell phone to plan the would-be robbery and the coordination necessary. Why do you say there wasn't?
Well, in our argument on the, and it's motion hearing 1419, in the argument, when the Commonwealth was arguing that, and I'm talking about the argument for the motion for a new trial, she said the texts were important pieces of evidence because the two other witnesses were facing significant charges. I mean, that was her quote, because the Commonwealth was trying to argue, hey, there was sufficient, there's plenty of evidence anyway, didn't really matter. Clearly, the motion judge felt otherwise. I mean, she said texts were important pieces of evidence because the two witnesses were facing significant charges. Well, they were.
That goes to the harmless error argument. We're not there yet. You're one step ahead of yourself.
Okay. Thank you, Honor. So you're asking me again, then I misunderstood what you were asking me. So I apologize, but could you repeat?
No, I was just asking you for your argument why there wasn't probable cause with the conversations with Mr. Jacobs and your client going to pick him up, having the gun, putting it in the trunk, all those issues, and that presumably cell phones would be utilized to coordinate everything.
Well, you know, there's a part in Carpenter and I think Augustine, but at least Carpenter, that said general statements like the two of them must have been communicating, because that's how they communicate to arrange things, is not enough. That's a general statement, and frankly, I agree.
But here, don't we have more? We have more than just, oh, they must have been communicating. We've got actual texts going out to the first victim, the foiled first victim, the text, the phone call between Jacobs and your client. Isn't there more than just general communication, but actual communication by cell?
Well, the communications to the victims, I believe, were done by somebody else, not my client. I understand it's a joint venture theory, but they weren't done by my client. And I argued in the brief that the communications between my client to Jacobs, or was it Jacobs to my client? I can't remember right now, but those communications, you don't know actually, you're assuming that it's my client, but you don't know who's on the other side of them. There's a bunch of communications to Jacobs. And you don't know who's on the other, you don't know what was said, you don't know what's on the other side. So I don't see that as a strong case in any means. And then the identification, I know now I'm jumping ahead of myself. The identification was just absurdly ridiculous, frankly. So I don't see that as evidence that this case was very strong. I don't know if you want to get to the ID yet, but it was one of the most suggestive identifications that I've ever seen. Anything else? I'm sorry.
You can continue.
Oh, okay, thank you. So I was going to get into the identification from Marina Del Mar. First of all, they both say under oath, one was promised, the first guy, Alvis, was promised no jail time. They wouldn't charge him with anything more serious other than accessory after. And he would, if he testifies, quote, truthfully, he would get probation. He testified to that under oath. And Marina Del Rey also said that if she helps, she would get no time and not be charged at all, or maybe being charged with, again, something very minor. As for the identification, I know under the new law this would not fly, and you would get incredible amount of instructions on this. But of course, Rodriguez was the standard then, and not Gomes, and certainly not Henderson in New Jersey. But she testifies at the first hearing she can't identify anybody. I mean, at the first identification. Second identification, which was after she saw a YouTube video of the defendant. Now I'm 75% sure. And then at trial, she testifies, oh no, I'm sure, I'm 100%. Wow. You know, I know now, after Gomes and cases like that, there would be, many instructions concerning that whole procedure. I don't think that makes the case stronger. I think it makes the case weaker for the Commonwealth. How couldn't it? Here you have a woman who says, yeah, that's him, 100%. I'm sure. Yet, I'm not sure.
If it makes it weaker for the Commonwealth, if the ID makes it weaker for the Commonwealth, where is your substantial likelihood of miscarriage of justice?
Well, I argued that under 33E. Because it was more of an ineffective assistance of counsel argument.
Yeah, I know, but that second prong's the same. That's why I phrased it that way. Didn't I not mention substantial miscarriage of justice? No, I'm sorry. No, you said that it makes the case weaker for the Commonwealth. I'm just trying to understand, if it made it weaker for the Commonwealth, how did it hurt your case?
Well, I'm arguing now on appeal that it made it weaker for the Commonwealth, but all that ID came in at trial, trial counsel objected to it when it was being introduced, but never filed a motion to suppress. Now, I guess the argument would be, why would he if that was not the state, if Rodriguez was the state of the law? But, and the Commonwealth kind of, I wouldn't say the word chastised, but kind of responded to this argument by saying, well, that me saying that the trial counsel should have argued, objected to it and argued Henderson, a New Jersey case, is absurd, basically. However, I want to say that Gomes, way before the law changed, at trial I'm talking about, Gomes cited the Henderson case. I mean, you have to start somewhere. And if Henderson was around at the time, all he had to do was say, hey, I'm citing this New Jersey case. Maybe they would say no, but there was no objection, no motion to suppress, until he realized, trial counsel, that, oh my God, he's going to say 100% identification. He didn't know that, because it went from 0 to 75 to 100. So I argued it under 33E, ineffective assistance of counsel, because your decisions, not but your court's decisions, have long said that if you're gonna, that the 33E standard on ineffective is more favorable to defendants than the others. So that's how I argued it. I put it in under 33E review because I think that was so prejudicial that it did create a substantial miscarriage of justice. I mean, all these parts of that identification proceeding are things that were addressed in all of your subsequent cases, starting with Gomes and going onward. Needless to say, any lawyer now would have asked for all the Gomes instructions, would have objected, would have filed a motion to suppress, would have done all of that. And even then, you know, Gomes didn't come from nowhere. I mean, the attorney knew what the law was, you know, how the law was changing and how the science was changing, and knew about Henderson and filed the motion anyway. You got to get there somewhere. And a lot of what we do sometimes in court is, all right, this is not quite the law, but we're going to do this because we want to preserve for in the future, or do this or do that. He just ignored it, and then all of a sudden was shocked when it came in at trial. That's why I argued it under 33. I can say that that ruling had to have a significant impact at this trial. Had to have. I mean, yeah, that's him. 5 days later, it wasn't him. 5 days earlier, it wasn't him. So that's my argument there. Oh, I see the time. Well, I'm going to rest on the brief unless you have more questions for me.
Does anyone have any further questions? Okay, thank you very much,
Thank you, Cecil.
Attorney Black. Okay, Mr. Charles.
Good morning, Your Honors. May it please the court, Assistant District Attorney Jamie Michael Charles, appearing for Middlesex on behalf of the Commonwealth. I'll start where my brother did, I suppose, with the question of the text messages. And I just want to say at the outset, unless this court wants me to, I'm not planning to address the CSLI. I think, as I mentioned in a footnote in my brief, I think it's pretty clear cut that under Hobbs and the case law that has come out, even if you suggest that the Commonwealth did have to make a higher showing than what was made originally at the Rule 17 hearing, there was ample evidence here that the defendant had a phone on him and was participating in the crime, which is really all that is required now in order to get an individual's CSLI under the probable cause standard. So turning to the text messages, and again, I guess I'll say here, you know, Justice Lowy, since you discussed it with my brother, I can see that it is at a minimum an open question about whether this would be preserved or not. But I think the Commonwealth's position, if you look at the motion for new trial hearings, and even now in our brief, is that really the question of what degree of prejudice needs to be shown is sort of irrelevant here, because the Commonwealth's argument is that there's ample probable cause under this court's case law. And if you look at the Fulgham case, as long as the Commonwealth can demonstrate that it did submit an affidavit, albeit in the context of a Rule 17 hearing, but it was before a judge, it submitted an affidavit. Chief Justice Gantz in the McCarthy case sort of alluded to this in his concurrence as well, right, in the context of electronic communications, that the Commonwealth should submit an affidavit, and then if it turns out you have to prove a different standard, the court can evaluate whether that standard is met. And so here I would submit that the Commonwealth satisfied the probable cause standard in its affidavit. And therefore, it really doesn't matter whether we're looking at this under harmless beyond a reasonable doubt or substantial likelihood of a miscarriage of justice, because the defendant can't even get to that second prong. I think both the Rule 17 judge, Justice Billings, and the motion for new trial judge, Justice Tuttman, separately articulated very clearly and eloquently why the Commonwealth met its burden here. So I just want to reiterate what they said. Justice Billings said that the affidavit established, quote, that each defendant used his cell phone in the planning, execution, and aftermath of the robbery homicide, as did two material witnesses. That's at page 64 of the supplemental record appendix. Justice Tuttman, in her opinion, said the affidavit, quote, does not simply establish that the defendant and other parties were communicating by cell phone on the day of the shooting. It points to specific instances in which their cell phones were used in the planning and the commission of both the attempted robberies and the shooting. The affidavit contains enough instances of other co-venturers using text messages and calls to further the commission of the crimes, such that it is reasonable to infer that the defendant's text messages contain similar evidence. And that's at 107, 108 of the Commonwealth Supplemental Record Appendix. And I'd say this is consistent, right, with this court's pronouncement in White and subsequent cases with the appeals court's Arthur decision. We certainly have direct evidence here that the defendant at a minimum made phone calls or was called by other co-venturers. But even if there wasn't direct evidence of the defendant's communications, this court's been clear that you don't need that direct evidence if you can show through other evidence that it's likely that there was communications among the joint ventures here. And I would say
You would say that there's an inference that Jacobs was talking to the defendant based on what happened afterwards and then what the defendant's duffel bag.
well, so I don't think there's an inference. Certainly you'd have to draw an inference as to what the specific subject matter of the conversation was. But if you look at paragraph 10 of the affidavit that was submitted in support of the Rule 17, and that affidavit is at page, I think it is page 31 through 43 of our supplemental record appendix. Paragraph 10 of that affidavit explicitly says that during his interview, Jacobs stated he called Daniel Lewis. So there's no dispute that they talked. And then I think it's clear from, I think it's paragraph 15 and 16, if you look at that, that there was information in the affidavit. The four central players here, right? Although Marina Del Mar was sort of on the fringes, the four central players were Mr. Lewis, Mr. Jacobs, Mr. Pierce, and Mr. Duarte. Now, the affidavit establishes that while Duarte, Pierce, and Jacobs were all physically together earlier in the day, going to get masks from the dollar store to sort of plan their crime, that at that point in time, when three of the four were together, Jacobs was speaking with another individual who was referred to as his cousin, I believe, who he was seeking to get firearms from, and that individual wanted to participate in the crime. The affidavit then establishes that immediately after that, they go to Boston and they pick up Daniel Lewis, and he has a black bag that is later found behind Pine Street, 50 Pine Street, that contains a gun. So I think it's clearly reasonable to infer that Daniel Lewis was the individual Shaquan Jacobs was talking to on the phone about procuring a gun, and then was picked up and subsequently participated in the robbery. So I don't think that's a close question at all. And like I was saying before, I think if you look, even most recently, I sent a 16L letter on Friday because I think this court's, I cited the appeals court's Snow decision in my brief, but subsequently this court last month issued its decision in the Snow case on further appellate review. And I think that's probably the most salient case in terms of establishing that you don't actually have to show that Daniel Lewis sent text messages to anyone for his text messages to be relevant to the event and to be authorized to be searched. Pursuant if probable cause is shown, right? In the Snow case, I believe essentially, I don't want to oversimplify it, but the defendant called his girlfriend regarding the car that was involved in the homicide immediately after the shooting. There was evidence of planning among the various co-defendants, right? As evidenced by people changing in the car and the fact that they all clearly came together from different locations. And finally, there was evidence that a co-defendant had communicated, I think, via text with the victim. So there was no evidence that this defendant in Snow texted anybody, but there was evidence of planning. There was evidence that a co-defendant had texted the victim, and there was evidence that the defendant used his phone to make a phone call. That's basically our case here. I would submit a stronger case here, right? Because every co-defendant involved in this, the four I've listed to you, as well as Ms. Del Mar, were all communicating amongst themselves. The affidavit establishes that. They communicated with both victims, Ms. Loeb and then subsequently Mr. Coveney, via phone and text. There's evidence that Mr. Lewis did, at a minimum, speak to Mr. Jacobs, and the strong inference in the affidavit is that that had to do with the crime itself and guns and procuring guns. And there's no question, if you read the affidavit, that this defendant was a central player in the crimes themselves, right? And that's why I sort of dismiss my brother's citations to the Morin case and Fulgham in his brief, because those cases had way less than what we have here, right? All you have in those cases is, and again, I'm oversimplifying just because I know both of them are slightly different, but essentially it's a co-defendant having phone communication with another co-defendant and the victim on the date of the murder, and a couple of other little things, but that's pretty much it. And in both cases, what was lacking was evidence that the person whose phone they wanted to search or whose text messages the law enforcement wanted to search actually participated in the crime. There wasn't, that hook was lacking in the affidavit. And so I would submit that here, there's plenty of probable cause in the affidavit to suggest that this defendant played a central role and was in fact the individual who shot the victim, Mr. Coveney, during the course of the second failed armed robbery attempt. That combined with the CSLI evidence, combined with the variety of evidence of communications in the affidavit, which I outline in my brief at pages 37 and 38 with paragraph citations, that established the requisite nexus here to look at communications. And as this court recognized in Holly, communications include real-time text messages, even if you only know the individual was calling. We don't narrow the scope that much if it's clear that there was planning, there was coordination, and these people were talking to each other. You can look at all the different ways that they would be talking to each other if you establish the requisite probable cause. And so if there's no further questions on that issue, I'll just briefly touch on the in-court ID. Again, I just want to stress that the Commonwealth did not attempt to introduce either of the pretrial identifications at trial. Those came in on cross-examination, which I would argue was a very effective cross-examination by defense trial counsel in an effort to impeach the credibility of the witness's identification of the defendant. But pre-Collins, under the case law that we had, whether this would now be admissible, I would submit is a much tougher argument for the
Judge
Commonwealth.
Totman went farther than, she went further than many judges did back in 2010. There's no motion to suppress. She does a voir dire and makes a determination that there would be clear and convincing evidence of an independent source from any unnecessarily suggestive out-of-court ID. And considering it was 2010 and the state of the law, it was prescient and pretty thorough the way she handled it.
So I think if you look, well, I admit that this certainly wouldn't suffice today on post-Gomes. If you look at the circumstances, what was elicited at the voir dire and what do we know about Ms. Del Mar and her exposure to the defendant? This was not a situation like, say, the Greenwood case from the appeals court that I cited in my brief, where a victim had 10-minute opportunity to observe his assailant, right? And in that case, that was sufficient to allow him to make an ID, even in the absence of a pretrial ID. Here you have essentially a cohort of the defendant who spends hours with him on the night of the crime, right? Both in the car together, conversing and observing him. And then later, also outside under street lights as they're attempting to effectuate both of the failed armed robberies. So this witness had an excellent opportunity to observe him on the night of. She testifies during the voir dire that during that October 1st photo array, the first where she failed to make an identification, she testifies that she had literally just found out that the victim had died and that she was extremely scared and confused and not thinking straight. So she provides a concrete explanation for why she didn't make an identification that night. And if you look, I apologize, I forget which footnote it is. It might be 15, but I may be misstating it. The Commonwealth sort of speaks to the fact that there were also different photos of this defendant in both arrays. And those arrays, by the way, have been reproduced in the Commonwealth Supplemental Record Appendix. In the first array on October 1st, there was a photograph of this defendant without cornrows, which is the hairstyle that Ms. Del Mar testified he had on the evening of the shooting. In the second array, which happened 6 days later, there's a new photo of the defendant with cornrows. And she specifically testified at the voir dire and on the stand that he appeared much more familiar to her in that second array because he looked more like the individual she remembered from that night, the individual with the same hairstyle. So I think that there's an explanation both in terms of the photograph that was used and also her state of mind to explain why she failed to make an identification on the first instance. And then on the second array, again, it was not an unequivocal identification, but I believe she ultimately said she was 75% sure it was him. I'd point out that her brief observation of a YouTube video had nothing to do with law enforcement, so there's no due process issue there because we're not talking about the suggestiveness of the photo arrays or any actions law enforcement took to taint her observations. We're talking about an extraneous observation that law enforcement had nothing to do with. And that's why I cited the Odwara case in my brief, because that was sort of a similar situation where a police flyer with the defendant's photo that was meant to be only for internal use ends up making its way into the community and several witnesses see it and then subsequently either make a photo array ID or a grand jury lineup ID of the defendant based, not based on that observation, but, you know, based on their observations on the date of the crime, having viewed the defendant's photograph in the interim. And the court ultimately said that that was fine. The court felt that there was a firm enough contemporaneous observation of both those witnesses at the time of the event, and that combined with the fact that law enforcement was not directly responsible for their observation of that photo suggested that
Was his face,
I'm sorry?
didn't he have his face covered at the arraignment to some extent?
There was some indication from Ms. Del Mar that the defendant and Jacobs, who was being arraigned at the same time, were covering their face. Obviously, I've never seen the actual YouTube video. It was not in the record, but
Because there could have been a common law argument for, there could have been a common law argument to exclude the evidence under unduly prejudicial.
I'm not dismissing that there could be a common law argument, but I mean, the case law suggested that it had to be especially suggestive circumstances. And I'm not sure that the observation of a let's call her a co-defendant who was with the defendant for hours on the night of the crime, seeing that same individual who's covering their face briefly be arraigned on YouTube is the sort of especially suggestive circumstance that would trigger common law suppression. And then as far as her in-court ID, again, at the time, the law was, if the Commonwealth could demonstrate that the pretrial array was not so impermissibly suggestive as to give rise to a very substantial likelihood of irreparable misidentification, then the in-court ID was admissible at the time. And Ms. Del Mar, when pressed by Justice Tuttman, stated that her identification was based on her observations that night, not on the fleeting observation of the YouTube arraignment. And so, you know, in the absence of a basis to conclude that her trial ID, setting aside the fact that she unequivocally identified him at trial and only 75% at the second pretrial ID, setting that aside, there was no basis to believe that that the experiences she had pre-trial, whether it be in either of the arrays or the brief observation of the YouTube video, so irreparably tainted what she did at trial, such that it had to be suppressed. It certainly wasn't an abuse of the judge's discretion to make that determination after conducting a voir dire at the defense attorney's request. And so I'd suggest that there's no ineffective assistance of counsel here based on the state of the law and what steps he took. And even if you find that there was error, which again, the Commonwealth does not concede, there wasn't a substantial likelihood of a miscarriage of justice here because of the overwhelming amount of evidence against this defendant. Two separate cooperating witnesses who were complicit in the crimes, who testified to the defendant's central role, CSLI evidence that not only placed the defendant with all of the co-defendants at relevant times, but other cell records that showed his communications with them, and also disputed statements he made to police during his interview. The fact that the black bag that the defendant was seen bringing into the car in Boston was then recovered from behind Pine Street, and I believe Mr. Duarte stated that he believed it was the same bag and that it contained the murder weapon. This was not a close case. This was not a situation. I'm not going to dismiss the fact that an ID of a defendant from a co-conspirator carries some weight. It does. But if we're looking at it from a substantial likelihood of a miscarriage of justice, if we want to assume error here, there was so much incriminating evidence here that it could not have substantially swayed the jury. So I would submit that the defendant still would not satisfy second prong ineffectiveness and would still not necessitate reversal. And I know my brother didn't really express it, but again, this also is not a situation where reduction of the verdict is warranted under 33E. This defendant brought the firearm. This defendant egged everyone on after the first robbery failed to get a new target, said he didn't come all the way out here not to do something. He shot the victim during a robbery that by all intents and purposes was over at the time. The other witnesses essentially said the victim said he dropped the Percocets, he was on the ground, he said just take them, we couldn't find them, and they turned to leave and then heard the defendant shoot the victim. And the defendant was laughing about it in the car, saying, I shot him in the rear. You know, his rear is burning right now. I'm not using the words he used, but so the defendant seemed to take pleasure in this. It was an unnecessary act at the end of a failed armed robbery. There's no reason, he was 21 years old at the time of the crime. There's no reason for this court to reduce the verdict under 33. And so I'd ask that you affirm the defendant's convictions.
Okay, thank you very much.
Thank you, Your Honors.
Hear ye, hear ye, hear ye. All persons having anything further to do with the Honorable Justices, Judicial Court, now sitting in Boston, sitting before the Commonwealth. At present depart, sitting in this court is now adjourned.